Namaskar. In this session, we shall be taking up an interesting proposition that came before Honorable Supreme Court in the case of Shantaben Bhurabhai Bhuriya versus Anand Athabhai Chowdhary and others with regard to the effect of direct cognizance and thereafter commitment by magistrate of offences under SC/ST Act in view of section 14 of SC/ST Act, whether the entire criminal proceedings for the offences under the Atrocities Act can be said to have been vitiated in such scenario. Now, coming to the background of the case, one FIR came to be registered against the husband of Shantaben Bhurabhai Bhuriya, original complainant appellant, for the offences punishable under section 323, 353, 362, 186 and 114 IPC at the instance of Anand Bhai Athabhai Chaudhary, was first respondent, original accused number 1, who was working as police sub-inspector, alleging inter alia that the original accused persons obstructed the public servants in performance of their duties and was beaten by them under the guise that they were not able to catch the thief and caused injuries to them. The Judicial Magistrate First Class passed an order for investigation under Section 173, subsection 8 CRPC by observing that summary report was not clear with regard to the involvement of the original third accused and other police officers. Thereafter, the Deputy Superintendent of Police, SC/ST Cell Dahod, submitted its report to the magistrate, pointing out that the alleged offences are prima facie appear to have been committed by the accused persons. Considering the report submitted by the Deputy Superintendent of Police, the magistrate took cognizance of the alleged offences by issuances of the process under Section 204 CRPC and summoned the accused. The same was, however, quashed by Honorable Gujarat High Court, mainly on the ground that in view of the amendment to Section 14 of the Atrocities Act, the special court can take cognizance directly and the jurisdiction of the magistrate can be said to be ousted. Feeling aggrieved of the impugned judgment passed by Honorable Gujarat High Court, original complainant appellant preferred the appeal before Honorable Supreme Court. Now, the question posed by Honorable Supreme Court was whether in a case where the offences under Atrocities Act, the cognizance is taken by the learned magistrate and thereafter the case is committed to the court of session or special court and cognizance is not straight away taken by the learned special court or court of session, whether entire criminal proceedings for the offences under the Atrocities Act 1989 can be said to have been vitiated as so observed by Honorable High Court in the impugned judgment and order. Before that, the legislative history of the section was also discussed. It was observed that while considering the aforesaid issue or question, more particularly Section 14 pre-amendment and post-amendment was considered. Section 14 as stood pre-amendment and post-amendment reads as under. Section 14 Special Court Pre-Amendment. For the purpose of proving for speedy trial, the state government shall, with the concurrence of the Chief Justice of the High Court, by notification in the official gazette, specify for each district a court of session to be a special court to try the offences under this act. Post-amendment Section 14 says special court and exclusive special court. Subsection 1 speaks that for the purpose of providing for speedy trial, the state government shall, with the concurrence of the Chief Justice of High Court, by notification in the official gazette, establish an exclusive special court for one or more districts, provided that in districts where less number of cases under this act is recorded, the state government shall, with the concurrence of the Chief Justice of the High Court, by notification in the official gazette, specify for each district the court of session to be a special court to try the offences under this act, provided further that the courts so established or specified shall have power to directly take cognizance of offences under this act. After the authoritative pronouncement by Honorable Supreme Court in the case of Ratiram versus State of Madhya Pradesh and others with regard to the delay in conclusion of the trial in the cases under SC/ST Act, it gave rise to the amendment to Section 14 of the Act by way of proviso to Section 14, that to be inserted by Act number 1 of 2016. Now, as evident, it has been provided that after post-amendment insertion of proviso to Section 14, the special court so established for the purpose of providing for speedy trial or specified shall also have the power to directly take cognizance of the offences under the Atrocities Act 1989. On the analysis of the judgment, it was found that considering the aforesaid legislative history which brought to insertion of proviso to section 14 of the Atrocities Act, by which even the special court so established or specified for the purpose of providing for speedy trial has now been empowered to directly to take cognizance of offences under the Atrocities Act 1989. It was observed by Honorable Supreme Court in the case of Shantaben that merely because learned magistrate has taken cognizance of offence and thereafter the trial of case has been committed to special court established for the purpose of providing the speedy trial, it cannot be said that the entire criminal proceeding, including FIR and charge sheet, are out to be quashed and set aside. The words used in the second proviso to section 14 are court so established or specified shall have power to directly take cognizance of the offences under this court, unquote. The word court only, unquote, is conspicuously missing if the intention of the legislature would have to confer the jurisdiction to take cognizance of the offences under the Atrocities Act exclusively with the special court. In that case, the wording should have been quote that the court so established or specified only shall have the power to directly take cognizance of offences under this court, unquote. Thereafter, merely because now further and additional powers have been given to the special court also to take cognizance of the offences under the Atrocities Act, and in the present case merely because the cognizance is taken by the learned magistrate for the offences under the Atrocities Act and thereafter the case has been committed to the learned special court, it cannot be said that the entire criminal proceedings have been vitiated and the same are required to be quashed and set aside. So in the end, it was concluded that simply because cognizance of the offence under the Atrocities Act is not directly taken by the special court, the entire criminal proceedings cannot be said to have been vitiated and cannot be quashed solely on the ground that the cognizance has been taken by the magistrate. Accordingly, the judgment passed by Honorable Gujarat High Court was set aside. Recently, the view taken by Honorable Supreme Court in the case of Shantaben was also referred to and followed in the case of Ramveer Upadhyay and another was the state of UP and another. That would be all for today's case note. Till we meet again, Namaskar.